Thank you. Hi, I'm Heidi Coad Hermelin, and I'm also on the Education Committee, and I'm going to be moderating this panel tonight. I'm going to have each person introduce themselves to get started.
Okay, I'm Carol Langford. Would you want me to tell anything about my background or just?
Sure, go ahead.
Okay. So I have a practice where I represent lawyers before the state bar and students in admissions cases. And I've done that for many years. I was appointed by the Supreme Court to the Commission for the writing of the rules of professional conduct that we are all going to be talking about today. I chaired the ethics committee. I've taught as a law professor at Bolt Hall, and I'm at USF, Hastings. I'm an adjunct, so I'm a soldier of fortune there. And written many books and chaired many committees and on ethics. So that's what I do is ethics. So I'm happy to be here.
I'm Jen Lee. I own Jen Lee Law, which is a law firm in San Ramon. I have offices in San Francisco and Tracy, and I'm here from the law firm owner standpoint. And I mostly practice bankruptcy law, except I don't use the word bankruptcy in any of my marketing. I help people with debt and credit issues. So figuring out what to do with those. So my part on this panel is I'm a big proponent of getting paid because in the bankruptcy world you're working with people that may not have money. And so I'm filling in that perspective tonight.
So a little bit about me. I have been an attorney for about 28 years, and I've worked in medium-sized firms, small firms, 4 or 5 attorneys. And I'm currently in a 2-person firm with my spouse, and I've been doing that for 12 years. And we practice in real estate bankruptcy, we do use that word, and business litigation. My office is in Martinez, and we do have 1 staff person, but I do most of the things that we're going to talk about in our office myself. So attorneys become lawyers for a number of reasons, some to help others, to have for the intellectual stimulation, maybe to protect the Constitution, whatever their reasons may be. But you can't do any of those things unless you earn a living by them. So tonight we're going to talk about how to get paid by your clients and stay out of trouble with the bar. And there's an agenda that many of you probably got from over there. So we're going to go through that somewhat loosely. If you have questions, she's telling me to speak up. So let me know if you can't hear me as well, if I don't glance all the way over there. If you have questions during a topic, feel free to raise your hand and we'll go through them. I also want to remind you that there is a sign-up sheet if you want to get the MCLE credit for this meeting today. Okay, so a lot of what we're going to talk about, as Carol mentioned, is governed by the rules of professional conduct, some of it by the Business and Professions Code. I've attached some of the statutes to your materials, and tomorrow Ann will be emailing you copies of some fee agreements, which are put out by the Bar Association. So you don't have to follow them, they're not mandatory, but they're certainly helpful for you to guide in preparing different types of fee agreements. So we're going to start with that topic. I'm sorry, we're not going to start with fee agreements. We're going to start with talking to your clients about money. That's my first topic on here. And so the question becomes, someone calls you, sets an appointment. When do you talk to them about money? Do you talk to them when they make that first phone call? Do you wait till they're sitting across from you at your desk? And do you charge for that first consultation? I'm going to have Jen address this because she feels passionate about it and give her insight.
Okay. This is my baby. So I am a big fan of having a profitable law practice and being able to function and help your clients. So I encourage lawyers to charge for consultations. In the bankruptcy world, I am one out of many in the area that everyone else does a free consultation. They do a free initial consultation to evaluate whether you qualify or whether you don't. I have found that if I charge for that initial consultation, the talk about money becomes easier because someone can afford the initial consultation. That means they can probably afford services. If they are looking for a free consult because they can't afford legal services at all, then your chances of being able to retain them are lower, I guess, is how I would put it. But and it doesn't have to be a lot of money, just make it worth your time. But I am a big proponent of charging for your advice, charging for your knowledge, because you can sit there and do free consults all day and at the end of the day, you haven't made anything. You've spent 8 hours doing free consults. So just make sure you follow the rules, as Carol will say, as on how you charge, if you do a flat fee, if you do an hourly rate, that kind of thing. But yeah.
Let me add too that we're talking about prospective clients.
Right.
And so there is a new rule 1.18 on prospective clients that we used to not have before in our rules, because our rules are now reading more like the ABA. And it also, in that rule, talks about confidentiality, and you have the same duties, so for conflicts checking purposes and the like, to a prospective client who has given you information as you would someone who actually retained you. If you do charge, you've been actually retained, so that moves them from a prospective to an actual client. And, you know, I like the idea of charging them something. I don't always, but then I don't give substantive advice until I'm retained, because they'll go off and take it and then mess up, and then, you know, you're the one in trouble for that. So you have to be really careful about that, I think.
And I will say, my initial consultation, there is a fee agreement. There's a written agreement that says what they're getting out of that session. They're signing off on that relationship from the very beginning. So it is documented.
And the scope of services is
Yes.
documented, which I think is the most important thing in a fee agreement.
So what I do in my practice is my intake sheet that they fill out before I meet with them will give a list of the other parties so I can run my conflict. And it also has a place for them to sign, and it lists all of our hourly fees and so forth, so they know before they come and sit in my chair what it could potentially cost them. I don't charge for all the consultations. It depends on what they want. If they want me to just let them know if I'm interested in their case and if I can help them, if it's in my expertise, I don't charge for that. But if it goes much further, if I'm going to prepare something for them or give them substantive advice, then I definitely charge for that.
Yeah, there's a marketing aspect. I mean, you want to, you know, get them to come to your office, and sometimes you do that by not charging initially, but then, you know, you can't give substantive advice, I don't think. Also, if you're charging them, it's a flat fee, so you are subject to the flat fee rule. Now, we used to not have it the same way, but with a flat fee, if you're going to put that money, you know, earn that money earned on receipt, you have to have the fee agreement with the language. And the language it's in Rule 1.15. And so you have to tell them that you are not putting the money in the trust account. And, you know, there's one more thing you have to say on there. It's right directly in the rule.
Yeah.
And so, you know, you definitely want to look at that rule, that the client has the right to require the flat fee be deposited in a trust account. The client is entitled to a refund of any amount of the fee if they terminate services, the unused portion of the fee. In the old days, we didn't have that. You could just take that flat fee and put it right in your operating account with nothing in the fee agreement. But we changed it because the legislature, the Supreme Court, Cal Supreme Court, they all wanted it. Yeah, I didn't like it. I didn't think we needed it, because I think if lawyers are going to steal, they're going to steal out of the trust account. They don't care where the money is. But they wanted it to have the appearance to the public that lawyers were protecting the money.
So now that we're moving into the different types of fee agreements, that's a good segue. Jen, do you want to talk any more about the flat fees, because that's a major part of your business?
So in the bankruptcy world, flat fees are very common when you're representing debtors. On the creditor side, it's usually hourly, I believe. Most people do. But on the debtor side, they like the certainty of a flat fee, not running up attorney's fees, not getting a bill at the end. And if we're filing bankruptcy for someone and they still owe me fees when we file, it's discharged in the bankruptcy. So that's not a very good business model to discharge your own fees. So a lot of the work that I do is flat fee, but I also, when they came up with the new rules in November of 2018, I revised all of my fee agreements to correspond both to the bankruptcy law, because we have to disclose fees there, and the new California laws.
Okay, so you're flat fees. I'm mainly flat fees too. I do charge hourly as an expert witness or a consultant. And the State Bar has those wonderful fee agreements that you can use. And I don't know if the newest one has the language out of 1.15 though. So, because the State Bar is, you know, struggling a little bit, I think, watching their money. And I don't know if they've yet revised them according to the rules, so you'd have to add that language in. I would say one thing, unless you're going to get to it later, on costs, fees and costs, right?
Advancing costs.
What?
Like advancing costs? Or
No,
handicap? Okay.
just costs in that fee agreement to be careful about. An opinion just came out like today by the mandatory fee arbitration, but it's still got a draft number 2018-0X. That's a draft number. But it talks about costs. And, because lawyers like to say, I'll charge 4%, a 4% administrative fee for costs. 4% of what? Of your fee as an administrative fee. You can't do that kind of thing. Administrative fee, I mean, your rent is your rent. That's part of what you pay, not the client. So it talks about what costs you actually can charge. You can say, for example, 20 cents a copy when I copy things, but you have to put that in the fee agreement or you're getting the actual cost, which is like, I don't know, the cost of your energy to walk to the copy machine, 1 squirt of ink, the drum roll prorated over 1,000,000 times. It's like 2 cents. So they do talk about costs and what exactly you could do with costs. And it's online today. It just came today at 1 o'clock because I pushed them to put it online. I said, well, man, people have to see it. I'm doing a program. So you can find it there and it'll be interesting to you. Just go online and type in MFA mandatory fee arbitration committee of the State Bar, and it's 2018-0X. If you can't, tell me, and I can PDF it to you. But it talks about what costs could go in there.
So in those fee agreements that I mentioned that Ann will be emailing to you, there isn't one specifically from the bar about flat fees, but there is a provision about suggested possible things you can put in your fee agreement, which doesn't, I think, cover that language. And they also do call out the costs where they're naming them by topic, which I think would comply with the new law rather than just a broad cost amount.
I think you just have to understand with flat fees, that's important, is that even though you're charging a flat fee, I would advise all of you to still keep track of your time. I started at Pillsbury, what's now Pillsbury Winthrop. It was Pillsbury, Madison, and Sutro. I was at the big firm, so Melviny and all that. They made us keep track of time. And I never stopped keeping track of my time. And I think if you charge a flat fee, a lot of lawyers don't want to keep track of time, but you should. You just create a sheet with date, client, what you did, and the amount of time spent. And then if, say the client terminates services, you have to show them a bill to keep the portion of the retainer that you earned. And if you don't remember that 3 months ago you did something, then you don't get paid for that. You have to go, it takes hours to go through a litigation file. Far better to have kept that time, and then you create a bill and you send them a refund check of what they're owed, if anything.
Would you put an hourly rate in a flat fee agreement? Say, if I get terminated earlier, I'm going to collect this hourly rate, or if there's no language in there?
Well, you got to be careful about anything because collect whatever you're going to collect, because you have to fulfill the services. In other words, if it's $5,000 for, I don't do bankruptcy, but for a complete bankruptcy, and they terminate services when you've only done half the work, even if your hourly time is over the flat fee, your agreement was that amount for the whole flat fee, so you're not going to keep all that money. So you got to be careful about, I will charge $500, because then it's an onerous hammer, meaning they can't terminate you, and it's not true, because you're really not going to charge $500 if it ends up being $50,000 instead of the $5,000 they paid you. You won't be allowed to by the bar. So you got to be careful of how you say that kind of language. But you can say, I normally bill at $500 an hour. That way they get it in their mind. The unused portion could be billed at that.
So would you recommend putting that in a flat fee? I normally bill at X amount per hour, however, this will be a flat fee.
You could do that. Or just, if they terminate services, you say, this is my rate. As long as you can justify that rate, you've been out long enough to earn the $500, that's around what people at your level would and age in the practice would charge. I mean, you got to be able to justify that rate. But if you can, then yeah, you can.
And as a law firm owner, tracking your time, you want your law firm to be profitable. So tracking your time lets you know whether it filters down to profitability. And so I recommend tracking time on everything. My attorneys all track their time, and we compare them each month if we're losing money on a flat fee, if we're making money on a flat fee. because it's really important that you know where you're spending your time, where your employees are spending their time. If you don't know that, your numbers, your metrics are going to be way off because you have no idea what everyone's doing. Especially in my firm, because we're all remote. I'm not looking at them, so everyone works from home.
So kind of along those same lines, another type of fee agreement is where it wouldn't be one flat fee, but it would be a set amount per job that you're going to do for them. So for example, it may be to draft, discovery demands for them or help them respond to them or something along those lines. So that is a piecemeal, and it is a flat fee, but you're keeping control. You have more insight as to how much time that's going to take you after you've done it a few times. And they have the predictability of how much it's going to cost. It keeps them on a budget when when it's earned, because you're done with a smaller project than an entire bankruptcy.
I would just say, I call that the add-ons approach. And the only thing I would say about that you have to be careful about is if you're charging like $5,000 here for this and $5,000 for that and $5,000 and $5,000, and your total bill becomes $100,000 when a regular lawyer, the average lawyer, would charge $25,000, then it's an unreasonable fee. And you can get disciplined for an unreasonable fee. I mean, you can go into fee arbitration, you can do whatever, but ultimately you don't want it to be too high. I get it, why you want to do it. I mean, it's tempting because you can make more if they pay a little here and there, but you got to be careful about it, I think, doing that, because it does add higher a lot of times. You don't want it to be too high.
How do you document the add-on? So I imagine you're not writing a new fee agreement each time. Is it sufficient to agree on a flat fee for preparing discovery to response?
You are doing a fee agreement for each one.
You do a separate fee agreement for each one.
Oh yeah, because it's a separate flat fee.
Okay.
You have to.
Yeah, I do. Occasionally we'll do something similar where we're working through a case or consulting on something. I do a separate fee agreement every time we hit a new milestone that we're doing. Yeah. Okay.
That's wise. I mean, really wise.
I don't think the big firms do that.
Big firms are different. They are different because they have more sophisticated clients who aren't going to complain. They know how much litigation costs. And, big firms also, because they deal with corporations or different clients, they don't always have to have a fee agreement with the same corporate client. That's in the Business and Professions Code. So they take advantage of that, but that's very different than people law. I mean, there's big firm law and what I call people law, which is what we do and what a lot of you do. And when you do people law, you got to have a fee agreement each time you do those separate flat fees, because those are the clients that complain to the bar. Does big law have client complaints? Never. What happens with that is it goes into legal malpractice in the civil arena where they think they're going to get money, because you don't get money out of the bar. It's people law where the complaints come from, which is why you want the fee agreement, because that's Exhibit A in your discipline, right? What did that fee agreement say? So that's kind of how it ends up working.
And kind of along those same lines, there are certain requirements about the fee agreements for the bar. If it's a corporate client, it doesn't have to be in writing. If it's $1,000 in total for costs and fees, it doesn't have to be in writing. There's some exception also for repeat clients and repeat business, but there are very few exceptions, and I did include that in your materials if you want to look through the Business and Professions Code on that. Or sorry, the Rules of Professional Conduct.
And from a people lawyer standpoint, everything I do is in writing. Every time I meet with a client, it's because I often will do multiple strategy sessions with a client while they're trying to figure out if they're going to go bankruptcy or not, and I charge $199, and I know it's consumer, $199 for each one of those. Every time they come in, they sign off on a new agreement that says this pays for this session only. Anything else will be under a new agreement.
So we haven't talked about another big type of fee agreement, which is the contingency fee agreement, and that's very popular in certain areas of practice. It's not mine. I don't do any contingency work. But again, the bar has a model sample fee agreement that you'll be getting that has a lot of those provisions in it. There are some mandatory provisions for that. Do either of you do any contingency work?
I've done some in legal mal. I think the biggest key with contingency fees is what Heidi's saying, and what you're also stressing is use the bar fee agreement and have a fee agreement. I think the biggest thing is that you have unhappy clients who have been hurt, and you can never make them totally whole. So you're getting clients who are already going to be the ones who are going to complain. Family law, PI, and some real estate are the highest complaint areas at the bar. So with the fee, explaining it once you get it, I think, if the fee agreement is clear, it's when the money comes in and you're sitting down with them, which you need to do in your office. Don't let them call or Skype or anything. Have them come in and say, here's what came in, here's all the bills that we had, here's why we had them, and here's what your check amount is gonna be. Then they're okay. But if you don't do that, you'll get unhappy clients with a contingency fee. And you don't want that, because contingency fees with small firm practitioners, those people make more money than any other practitioners. If you're willing to try cases and take contingency fees, you'll make money. So, but having that agreement and sitting down and explaining it to them as you take the fee, I think is the most important part of the contingency fee.
I had a client who was we were going into bankruptcy, but there was a contingency involved with a Fair Credit Reporting Act that they were handling with another firm. And the fee agreement was contingency or hourly, whichever was less. And it came in that the fees, like she won $80,000 in the case, but then her check was like $30,000 because of all the costs that were associated. And she was very upset.
Yeah.
I had to calm her down when she was crying in my office. So it's really important that they understand what the fee agreement is, and then when you get the check, that you sit down with them and outline it, as Carol said. Every line, this is what the cost was, and then have them sign off on it saying, we understand that this is what it is.
Could there be a success fee? For example, I do trademark litigation. Generally, if you've settled it properly, there's no money exchanging hands. So how do you I had a potential client ask me if I could do something in contingency, and I said there's really nothing to tie that fee to. Do you ever see where there's like a success fee? Not a true like percentage of money recovered.
In addition to hourly, is that what you're
No,
saying?
instead of hourly.
Instead of hourly.
So in other words, it is a contingency fee because you're not collecting a dime if it's not successful. Is that right?
Yes, but the money, my percentage would. There's no award.
No, I
or
get that.
recovery.
There's no,
Yeah.
what do you call it, rest.
Right.
But
If successful.
But
there'd be a
if not
fee.
successful, right, you don't collect a dime, is that right?
Right,
How would you base the success?
right, okay.
See, I think the
That's
problem
a good point,
is
yeah.
that you would have a tendency, like we all would, to get greedy. I would. I mean, success fee. Okay, well, shoot, this app could be worth $20 million. What's my success fee? And so I think that you would have to look at the amount of hours you actually put in. Say you only put in, because you're good at what you do eventually, it won't be that hard for you to do. Say 20 hours. Well, then you're not getting any success fee of, 100,000. So if it's tied into actually the amount of hours a little bit, and maybe a little more, you guys could set almost like a flat fee, success fee, probably. But that can get complicated.
I mean, what happens if right before the success, the client fires you?
Yeah.
Yeah, well then you're in quantum Merowit land. You're at the mandatory fee arbitration arguing why you're entitled to that success fee. But that's a really good question. So what I'm going to do is I'm going to go on to there's a site of colleagues where we talk about issues like this, and I'm going to ask them what they think about the success fee. If you want, you can email me, and I'll tell you what they said, because that's an interesting way of like, how would you, with no rest, how would you make it reasonable so it would pass state bar muster?
What is this mandatory fee arbitration, which you speak? They didn't teach that at law school.
Mandatory fee arbitration, contractor bar. How you want to?
They do teach it in law school. It's part of the MPRA. It
It's-
was just a moment.
The mandatory fee arbitration is the best thing since sliced bread, and the Contra Costa County Bar offers it.
They don't, actually.
Oh, they used to. I was a fee arbitrator.
I
Okay,
know.
maybe they don't
don't
anymore.
do
They
that.
used to. The state bar offers it, and sometimes other bars offer it. But what it is you basically don't pay a lawyer, and when a client complains about the fee, you give them the notice of the right to arbitrate. then the bar assigns someone like me to look at it, and then we look at it. You don't pay a lawyer, it's cheap. And we make a decision on what we think, hearing you and hear the client who has no lawyer. And we both kind of look at it and see what happened and then make a decision. And it is a good, I mean, there's some good fee arbitrators. They're dirt cheap. It's really the way to go if you have a fee dispute with your client.
So it's mandatory if I write it into the initial fee agreement?
No, it's mandatory because it's mandatory whether
It's
you.
mandatory because it's out there in the general law and it's.
Yes, because clients always have the right to fee arbitration of your fee contract.
And that's in
Always.
the B and P code somewhere, or?
Yeah, and I just don't remember what mandatory, which one it was, but Contra Costa Bar used to have a great program.
They
You
dropped
might
it.
want to reinvigorate that.
But if the client doesn't like it, they can sue you in civil court.
Yes, if the client doesn't want it, but
Yeah.
see, to me, it works better for the client because they usually want it. Why do they want it? Because they can make it non-binding, so if they don't like the decision, they can overturn it and still go into court. They don't have to pay for a lawyer. They get a decision by someone who's gonna be just like a judge or a jury. I mean, I know fees. I'm gonna sit there, look at it, decide what I think, and it's a pretty good decision on those fees. So you get that for nothing. I mean, you pay a filing fee of, I don't know, a couple $100. I think the maximum at Contra Costa, the maximum for a huge dispute was $500, and you can get it back if you win. So, like, who doesn't want to do that for lawyers? And here's the bonus: clients cannot allege or recover for legal malpractice. That's nice.
Clients can't what?
They cannot recover for legal malpractice. They can recover lost value of services if, for example, you didn't file something you were supposed to. That's technically legal mal, but they're not getting a judgment for legal mal. It's just a fee dispute decision of how much is owed. So it's better for lawyers. You don't want anything with malpractice, God help you. You'd have to call your carrier and everything else.
So to go back to his question about the notice, I did include a notice in your packet. There is mandatory language in there. And you cannot sue your client for your fees unless you've served that on them. You can serve it with the complaint, but generally better to serve that on them before. And they only have a certain period of time to invoke their absolute right to the fee arbitration, and if they don't, then you don't have to go to fee arbitration. You can choose to sue them for your fees.
Don't ever sue for your fees, though. No.
Can you include language in your fee agreement that says that the parties will mediate before they go to arbitration, preferably, and then if it can't be solved, we'll go to arbitration?
That's a good question, and that law changes all the time. And so what you need to do is go to the bar site and look at their form fee agreements and see if they include.
They don't, that's why
Well,
I'm
then
asking.
they don't have to. See, you can't impose, you got to think of it this way, right? It's client's money and your fiduciary duty is to the client, right? So you can't impose restrictions on how they're going to argue over their fees, just like you can't impose restrictions on whether they call the state bar or not. So, they can do what they want. They can turn around and sue you. They can mandatorily fee arbitrate. It's up to them. It's not up to the lawyer.
So it's basically, if you put it in there, it's precatory language that
You could
I
put
would
it in
like
and
you to
clients will
do
look
that.
at it and go, well, I guess I
Right.
can,
Aspirational.
but they can't.
Yeah.
We can aspire to resolve this dispute.
Right, that's what I said, precatory language, it would be nice to do that first before going to the next step, but they're not bound by it.
But I
Yeah,
think once
it's-
you file a fee arbitration, they ask you if both parties are willing to mediate. At least that's what CCCBA did.
No, does Contra Costa Bar still have fee mediation?
No,
Oh, okay. That used to be the best program. Truly was. You
I
guys
didn't
have to-
cancel it.
You guys have to reinvoke that again because that program was great. I settled so many cases and legal mal too. I mean, just went in there and it was like, here's what is going to be decided.
We
Pay
all
up.
Are sad. We
And
all
that-
are sad. I'm going to the bar meeting this year to complain about that service.
See what they
we're going.
say, yeah. Why they did that, why they took it away, I don't know why. Probably
So-
money.
The other thing about that notice, it's not just before you sue them, but if your client raises an issue about your fee and you have a dispute about it, you're obligated to give them that notice so they know what their rights are. So even if you're not terminating your services at that point, I still think you're required to give them that notice.
Yeah, you gotta give them the notice, so they know.
So the other,
Is that a rule? Is there a rule
Yeah,
number?
notice of fee arbitration, just go online, you'll find it.
Okay.
I'm sorry, go ahead.
that's okay. So the other type of fee agreement that we haven't talked about is an hourly fee agreement. That I believe is the most common. We do use hourly fee agreements, and with that comes billing. And so there are some rules about the bar about billing. Doing my research for this, I didn't find a lot. You are supposed to prepare written bills for your client, but unless they request one specifically, there's no real time frame that I could find. But if they do request a bill, you're supposed to give it to them within 10 days of that request.
For hourly, so I don't do a ton of hourly work. I do in the Chapter 11 context because the court has to approve our fees in the Chapter 11, and so the court hasn't caught up to the 21st century where they look at flat fees. So I do have to do hourly billing for that. And then when I consult, I do a lot of consulting with civil litigation and mediators on things. I do hourly for that as well, but everything's in writing, and I bill 15th and the 30th usually.
Yeah, and you can, the rule that we put, it's the same old rule, what we call it 1.5, right? Because we numbered the new rules like the ABA rules, because we believe that lawyers are going to start, practicing in other states more. We're going to have reciprocity with the bar. We want one set of numbering for the whole United States. But 1.5 is now the rule. And we added 2 factors, and the 2 factors, you know how all the factors that they have for fees, like the novelty and difficulty of the question, the sophistication of the lawyer and the client. Those have all been around forever. The 2 new ones are whether the lawyer engaged in fraud or overreaching in negotiating the fee agreement. That's new. And the second one is whether the lawyer has failed to disclose material facts. In other words, you didn't tell them everything they needed to know, like there were other things that were going to blossom out of the scope of work that was going to be an add-on, and that's the kind of thing we're talking about in those 2 factors, 1 and 2. So just be aware it's in 1.5. With hourly fees, it's the reasonableness of the fee. That's all it is. Like, did you actually do the work? Did you do a good job? And that's really the key. I mean, where it becomes harder for newer lawyers is when you take 20 hours to do something that a lawyer who's been around forever would take 10 hours. I always tell people, if you're gonna, if you're new, you bill 10 hours, or maybe 12, but you don't bill 20. You don't bill to learn. And the next case, you've already done one, so it's gonna be a lot easier on the next case anyway. And you won't have to relearn everything again. But be careful about billing to learn, because then the client can complain about the bill.
What if the client, you explain to the client, this is a little outside of like my regular practice area, and you say, I'm going to have to do a little bit of research, maybe like 1 to 2 hours on this. Is that okay? Like, upfront, and they say, okay, yeah, we, instead of them going to find another attorney just for this, like.
I think, you're talking about 1 or 2 hours, but I think where it gets troubling is, for example, the $50,000 DUI case where, most lawyers would have charged $12,000 or something, and the lawyer charged $50,000, and the bar found that was very unreasonable. Because again, it's people law. When bills get a little more and it's a big firm, it's a little different. But I just think that 1 or 2 hours maybe where you talk, because the client then buys into it. But when it starts getting more, you got a problem. And you've already told the client you're billing to learn. So you've already given them ammunition to chop that bill down. So know that. Clients will all, yeah, that's fine. And then later it's not fine when they get a giant bill at the end and say, hey, take a little bit off. Come on, you actually bill to learn here. And then, you're stuck. You want to take that off.
What about the opposite of that, like recycled work product? I've seen some attorneys, you're smiling, because I've seen some attorneys in bankruptcy court get in trouble. And I think you wrote an article addressing it at one point in time, but have the new rules addressed recycled work product?
I call it the billing bonanza, recycled product. That's why we have flat fees, my friends, because you're recycling product, and it's okay to recycle product with a flat fee. The problem comes in the hourly fee where you're recycling, because it's taking you take a memo, and God help you, you better change the names in it. One time someone did it without forgetting to change a couple of names.
In bankruptcy, I remember.
And charged a fortune. But, you know, if it's on hourly fee, you can only bill for the time actually spent. Now, if you're recycling, the time spent could be 2 hours. So, but, you know, you're billing, you know, for doing motion, whatever, which is why the flat fee's perfect. Because even though you only took 2 hours, it doesn't matter with a flat fee. Because a flat fee encompasses your knowledge and expertise in bankruptcy and that kind of thing, which is why flat fees are so good for things like bankruptcy, where you reuse forms, some family law things, and that's how you get around that billing bonanza, which is wrongful, because you can't with an hourly fee. You could only bill for the actual time spent. Now you could, I'll tell you what you could do. You could put in that hourly fee agreement, you could say something like, when I recycle product, for example, a memo that I've done before, I will not charge you the full, for example, 20 hours it initially took. But I may charge you 5 hours instead of the 1 hour. Or you could do that. But the problem with doing that is most clients are going to read that and go, I'm not paying for that. Get out of here. This is an hourly fee for a reason. People are smart now about bills, especially young people that are coming out of law school. So they're smart. They're like, you know, and so I would just do a flat fee to get around it.
How about a hybrid? Let's say if you know you're beginning a case and you estimate the complaint will take you a certain amount of time, can you charge them a flat fee for preparation of the complaint or the answer, and then thereafter hourly for substantive work?
You can do some of that, and that's why insurance companies do that. Like they'll say in construction litigation, which I did in Contra Costa County for many years, you know, we'd do an answer and it was like 0.50, which is half an hour. And even though it took 0.10 because,
Right.
you know, and the insurance companies said you can bill that amount for an answer because we want you to work on our cases, and we know you're not going to, you'd go bankrupt, you wouldn't be a profitable company. So you can do that for some things, sure.
And it works in bankruptcy. The flat fee in a bankruptcy is for specific items. It's representing them in they're meeting creditors, doing things like that. There's always, in almost every bankruptcy attorney's fee agreement, an exclusion that says if there's an adversary proceeding filed, if there's some kind of complication or a lawsuit filed, then we have to enter into a fee agreement, and it likely will be an hourly type litigation case. So it is a little bit hybrid to that extent.
Yeah, you can use hybrids.
Can I
The
say
key
something
is the
about-
reasonableness of the fee. The overall, is it too high? Are you being greedy? Ask yourself that. The reasonableness of the fee overall. That's the key takeaway.
So what are the metrics, other than you talk to other people to figure out?
1.5, I just told you. The rule that has all the metrics in it lists
There's 13 of them.
13 metrics.
The market. So I'm talking about, if you're starting out and you're trying to figure out, you talked about the person that charged 50,000. And the determination was made that case only the attorney should have only charged 15. Maybe that attorney thought that was a reasonable fee for the work that they did because they didn't do their market research on what the market fee is. Do you see what I'm saying?
Yeah, but he should have. That's his downfall.
So what does that look like? I mean, I know that just through networking and you go online and you try to suss out in the Bay Area it's this.
Call. Just call people and say, look, I'm another
do you
criminal
charge?
defense lawyer, and I need to know how much you charge for this if you're willing to tell me, because be polite. My name is so-and-so, you know, and I'm new here in town, or I'm young and new and just starting my practice. I don't know. I'm really kind of unsure. Join groups. Like, the best thing you can do is join, like, bar association groups. At the Contra Costa Bar is perfect. And find the group that suits your purposes and ask around. Go online, fill out questionnaires, and say, look, I need to know. And you'll figure it out pretty easily talking to someone. You need a mentor lawyer is what you
I was
need.
going to say, join a mastermind. If you're not masterminding with other lawyers that own their own practices or that are starting out, you should be. Because talking and figuring out what other people are charging is hard. but it's easy if you have other people to bounce ideas off of. That's the biggest complaint about solo practice is you don't have that water cooler talk, you don't have anyone to talk to. Find your group or make your own group.
There are tons of state bar groups that are going, I mean, there's a criminal law one, there's a ethics one, there's a real estate one, and they go begging for people to apply to be on, because it's a little bit of work, you know, but you meet everybody. You get clients that way. They give each other clients. They'll tell you how much to charge. They'll be happy to tell you how much to charge. So you got to find your tribe, whether it's in your local bar or the state bar, and go to events like this. Everybody in here, there's probably someone else that wants to do your area of law that could talk to you right now about what they charge. And that's how you're going to find out and do it, I think.
One of the things that you said, though, because I'm a recovering litigator and now I'm doing trust and estate practice, is I always had to keep my time for the insurance companies, and even though I charge a flat fee for my services, I keep my time, everything I do, no matter what, and then I can look at, because you're gonna start doing some of the same things over and over, and they're not gonna be unique, and you can look at and go, well, this took me 26 hours the first time, now it's taking me 13, and on average it's taking me, 3 months later about 10. And if you have kind of an idea from other people what the hourly rate is, you can look at that, like you said, and gauge your metrics. Am I making money? Am I losing money? Am I charging too little? Am I charging too much? It's a little bit of work, but if you're in that mindset that you keep your time, it does give you a really good benchmark to see if you're charging too little, too much, and how much time you're taking over time.
And you have to know, folks, you're gonna look. There's going to be cases where you completely undercharge, for sure. And then there's going to be some where, hey, it's less work than you thought. That's the thing about flat fees. They kind of even out in the wash. Because the key is the scope of work. If you've taken on enough scope of work to justify that flat fee, the bar is not going to check the flat fee, even if you did 5 hours of work. Because the scope, you could have had to do other things realistically. That's a flat fee. The client gets the benefit of that bargain is, hey, if I really need you, I got you for a good price. If I don't need you so much, maybe I paid a little more, but that's what I paid for, a sum certain that I knew I was looking at, and only that. And that takes time. That takes doing your area over and over, and then you go, okay, now I see what the value is. Now I get it.
In people law, do the flat fees generate more or less fee disputes than?
Less. Because of some certain people like that.
Yeah.
Don't you think?
No, so the reason why I like flat fees is because from a sales standpoint, and you all need to take a sales course if you're looking at opening your own firm, but from a sales standpoint, being able to explain the value to the client with a flat fee is a lot easier. And I've noticed, as you were saying, as time goes on, I spend very few hours on a case now, but I'm still getting paid the same fee on most of them. So the value of flat fee is that you're profitable quicker, and your increase every year goes up.
And the money's up front.
Yeah.
Look, money up front is money in the bank. Money not up front, I always say,
I don't work for no
you may not get it. I mean, when people say to me, Carol, I want to pay half up front and half 60 days, I'm like, depends on what they say, whether I like their case, whether I'm interested in their case and I like them, because I just won't do it a lot of times now. But I always say to myself, if I haven't collected that flat fee up front, I'm not seeing that money. That way, when I see it, I'm pleasantly surprised. Because people always come, and what do they say? I don't have it. I'm sorry. I didn't mean to. And you're like, "Grr." And then, the hearing is 2 weeks away. And by law, I can't leave them in prejudice. So you got to show up for that hearing, even though you probably might not be paid unless you get in a big fight with them. And I don't like fighting with my clients. I really don't do that. So I just make it easy, man. Flat fee up front. And we both know what the deal is here. And I'll do a great job, and we don't have to argue. It works for me to do it that way.
So I think that experience tells you how much to set that flat fee out, because I think everyone would learn eventually that you'll set a flat fee, and it turns out that it's the client who wants to come in and see you all the time and talk to you for a half an hour every day, and now you've suddenly realized this was not the flat fee for you. So when we set flat fees, I kind of look at the issues in their case to see how much time it's going to take and get a little feel for them and how much hand-holding that they're going to need. And that's how I set it. And sometimes I'm wrong.
And setting expectations with the client for what's included in a flat fee, how many, if you're gonna set how many phone calls they get, emails, what your return policy. I have like a whole client packet that the client gets with, like, you can expect an email returned in 24 hours if you call, that kind of thing, so that they know what to expect. But then if they're starting to get really needy and that kind of thing, I will back up and say, hey, I'm working on this, here's our next steps. Keeping them informed and communicating, that's one of the biggest bar complaints is communication. And so I find that if I communicate and give them my expectations, then that flat fee makes it worthwhile because it's profitable.
Right.
You try and funnel them into a email communication, just so it's a paper trail in addition to
Yep.
not getting stuck on the
I use
phone?
practice management. I use Practice Panther for anyone who's, it's a cloud-based system, and all of our messages are within in that system, yeah.
So I want to touch a little bit on another aspect of fee agreements, which is waivers of conflict if you have more than one client that you're representing. So I was looking up a case today about the California Supreme Court, Shepard Mullen versus JM Manufacturing. I don't know if you're familiar with that. But in that case, they had an hourly fee agreement, but they didn't get an effective waiver, meaning that they didn't describe the potential conflicts that could arise or that may have already arisen between their two clients. And they blew up that fee agreement and said it wasn't enforceable. And so they went then to a quantum merit recovery for the attorneys. And a couple of the justices actually wanted the attorneys to have to give back all of the fees that they earned. So it's important that you do your waivers of conflict if you have more than one client.
I would say, folks, that it's a little bit of a separate discussion and away from conflicts, but yeah, you got to do your waivers for sure. You also brought up something really important, and it's a trend, I think, in the California bar now, and that is fee agreements that have provisions in them or lack provisions that are that make them unenforceable. So say you're supposed to tell if you don't have insurance. Well, say you don't put that in there. They just came out with an opinion saying if you don't do that, that agreement is unenforceable. So things like a division of fees, like, if I say to Heidi, we'll divide fees on this, thanks for giving me the case, and she's happy because she's going to get a kickback, which you can do. It's called division of, you can do a referral fee. But she somehow with the client or some way puts a provision or doesn't put a provision in the fee agreement she's supposed to put in there, then the bar can say that's unenforceable. And Heidi, you don't get anything out of Carol. Carol gets the whole 40% of that contingency fee. And Heidi might say, well, why should Carol? Because why her? Why don't I get anything? I worked. And the bars will say to you, well, then do us a quantum merit, which is a bad land to be in, quantum merit land. That's proving the value of your services, which means you're never going to get the same amount as a contingency fee. So in your fee agreements, what lawyers are starting to do, people lawyers, because it's a struggle sometimes, is they're starting to put provisions in that are unenforceable and unlawful in some ways, like the 4% administrative fee, like not telling clients they don't have legal malinsurance. This is becoming more prominent. In fact, today I sent an email to Randy DiFonternum at the State Bar. He's the head of competence. I said, Randy, you got to do an ethics opinion on this. These lawyers are going out of control on this again. And so they'll probably have one that'll come down. But just know that if you start monkeying with the bar language, which is approved bar language that you can have for free, that Heidi sent out to you and Ann sent out to you, that you might get in trouble and they'll throw that fee agreement out. And then you're in quantum merit land, which means you're proving what you did, what day, how much should that have been done. You don't want to be in quantum merit land. And you're fighting with the client, by the way, in fee arbitration or in court. That's quantum merit land, okay? Nobody wants to be there.
And remember, in referral fee land, if you're in bankruptcy court, you have to follow federal bankruptcy fee rules, and there are no referral fees for bankruptcy attorneys. So keep that in mind.
You can't give me a referral fee if I give you a bankruptcy case.
Not for consumer debtors.
Yep. Okay, good to know.
I would though refer you everybody. My clients are dead broke.
Not getting paid to near it, I don't want to be quantum mirror. When is the bar going to come after me for my ticket when I screw something up with a fee agreement?
Well, it depends. That's too broad a question. It depends on what you did.
You must see it. I mean, you must see it in your practice.
Well, but that's too broad a question because with the bar, you have to understand the bar is way different than civil litigation and what you guys see. With the bar, you're going to get a lawyer who often has a substance abuse or competency problem, right? That right there is not really a fee. It's a stealing from the trust account. Let's throw those aside. So if you're just talking about fees, when it's going to come up, I'll tell you, is going to be getting in a business deal with a client, and you're going to be tempted when you get these people who say, yeah, I'm starting a business in my garage, and I'm calling it Microsoft. And you're like, Microsoft? What a stupid name. Small and soft. What does that mean? And he says, well, I'm going to give you $100,000 shares of stock. And you go, well, I'll take it. I guess it ends up being worth like $100 million, okay? Those kinds of things where you get in a business deal with a client without complying with the business transaction rule, that's what the bar sees, taking advantage of opportunities. Clients come in and tell you, I'm creating an app for yoga. So you decide to create an app for yoga because it's so easy to do. You get a couple of venture funders and you're rich, you know. Well, you took that from the client. You see that. You see greed. I'm going to charge a 50% contingency fee plus cost plus where the client ends up with $10. So it's greed and business transactions and substance abuse.
So along that line, can we talk a little bit about trust accounting and how people can get in trouble there?
Okay. And what do you want to say about trust?
My biggest, what I've seen with trust accounting, so I don't do a ton of trust. Have an accountant. That's my recommendation for trust accounting. Don't try to do your own books. Have an accountant. The problems that I see as lawyers I've taken into bankruptcy that have trust account issues, the financial stress often causes them to take funds that may not have been earned yet out of their trust account for operating. So most of the complaints I see are misuse of trust account funds or not tracking trust accounts. I did have one attorney who got in significant trouble with the bar because she couldn't give them any kind of report of what was in her trust account.
Okay, that's bad. Trust accounts. Okay. I would say you guys are lucky because we don't do I'm not the state bar, but the bar does not do random audits of trust accounts yet. They used to not do random audits of MCLE either, my friends. And people started not taking the MCLE and lying about it. Now they do random audits. I think one day they're going to do random audits of trust accounts too. I can't guarantee you that, but I think they will one day. All I can say about that is I think you're absolutely right in that what happens is you get some young lawyers or new lawyers starting their practice and things get stressful. And come on, folks, it can go high for a while, can it? But eventually markets go down. People get under stress. They have to pay their rent, and they figure, I'm just going to borrow a little bit, and I'll put it back in as soon as I get my next client. I am here to tell you that in the history of mankind and lawyers, I've never seen it once, well, maybe once, out of thousands of cases where lawyers have actually put the money back. They just keep getting a bigger deficit because they're living beyond their means. Their practices is living beyond their means. They should be doing what you're doing, more where you do it in a way where it's financially viable. And so I would say that's probably with trust accounting. And one other thing I'd say about trust accounts, don't have one unless you need one. Now, the new rule says, which by the way I fought against it, but it says advance fees have to go in the trust account under the old law, Baranowski and the like of cases. You didn't really have to put advance fees in the trust account. Lawyers did because they were scared, but you didn't have to. Now, advance fees, a sum of money given on hourly fees, has to go in a trust account. So if you take advance fees, which I don't, then you have to have a trust account. Well, don't. and then don't have a trust account. I mean, I called the bar, Randy, a long time ago. I said, Randy, you know, should I have a trust account? Do I need one? He goes, well, do you take flat fees? I go, yeah, and I take hourly, but I bill out and I get paid. He goes, Carol, if you don't need a trust account, don't have one. And he said, because it's the trust accounting, bookkeeping, and record keeping is Byzantine. And if you're smart, you do exactly what she's saying, and you get an accountant to handle it for, you know,
From
a
the beginning.
cheap fee from the beginning.
From the beginning.
And, you know, but trust accounting is where lawyers get in trouble. And if you're one penny off, you shouldn't even be a penny off. So why have it unless you have to? If you're just going to take flat fees, as long as you have the language in the fee contract, you don't have to put flat fees. You could put them right in the operating account and spend them. Downside, if client terminates services, you better be able to refund. And if you've spent it, that's one of the things I learned as a young attorney in Walnut Creek. A client gave me a big advance fee. And well, it wasn't an advance fee, it was a flat fee. And I thought for sure he was going to have me, you know, go all the way through a bar trial, because I was young, you know, I didn't know. And it was such a big fee. And then he said, no, I don't think I'm going to do this or whatever. And I had to refund the money. And I put it like I could in the operating account. You could spend it. You could spend as much as you want. And all of a sudden I went, oh, crap. So I was getting money, giving him his money. And it taught me the most valuable lesson. You don't spend money unless you've actually earned it if you don't have other money. And I was a young attorney then, to actually refund all of it back. That's the downside, because lawyers are often tempted. They get $30,000, $40,000. I'm buying that Tesla. Well, now you got a Tesla. The client doesn't want a Tesla back. They want their money. So, and banks aren't going to loan you to give money back to a client because you spent it on a Tesla. Are your friends going to give it to you? They're going to be worried. So, you know, you got to pull out of your retirement, I guess, if you even have it. When you're a young attorney, you don't always have a lot. So I would just say that's the biggest warning for new attorneys and young attorneys, that you always have to assume services might be terminated and you got to give the money back.
So I have a trust account and I deposit costs and retainers in
You
there.
got to put costs in it.
And I use a program, it's called PC Law. It's, I think, awesome. It keeps me right on track. I haven't had a problem at all. I do reconcile it myself. There's not a lot that goes on in my trust account, in and out, but I do find that it's a very good system.
I don't understand, why are you putting costs into a trust account? What are these costs? Why are they going in?
Filing fees.
Filing fees.
Oh, okay, gotcha.
Deposition fees, all costs must be put in the trust account. Why? Why do you guys think?
Because you're holding it for the benefit of the client.
Because, yes,
Vendors,
it's
yeah.
being held for the client. You don't have any stake or ownership of those,
So
that cost money.
You got those costs from the client up front, that's where they're going in the trust account?
Yeah.
Okay.
You're getting them up front. See, what I do to avoid that is I just say, client will pay costs as they come. They pay them. So I avoid it because I don't want a trust account. But, you know, if you, trust accounts are handy if you settle cases and stuff.
Two quick questions. So if an attorney bills on the first.
If attorney bills what?
On the first.
Attorney bills on the first for the prior month, and they're taking money from trust, can they move it on the first, or is there a waiting period that the client can come back and argue the bill?
No, there's not a waiting period. In other words, if you've earned it, you've earned it. You must take it out because you've earned it. You must take it out as soon as you can. The client could complain, like they could get the bill and then 3 weeks later, after you've moved it, then the disputed amount would have to go into trust.
Got it. And then second question is, if there's a credit, like if people will accept credit cards for trust fund, where do those credit cards get charged? To the client as against the trust fund, or to the operating account?
I'm not sure I
The
understand.
processing fees,
Yes.
they go to the operating account. You should be using LawPay to make sure it goes to the operating account for the fees.
Square won't separate.
That's why you shouldn't use Square as a
I know,
processor.
we have one that shows as well.
Oh, because they don't do that?
No, they take it out of
They
the,
take it right out of the trust account, and then this attorney is charging their client the credit card processing fee.
that's just a
And I
bad
don't
business
think
practice.
that's right.
No.
But there's no chapter line and verse in the professional code.
Doesn't matter. If it's processing fees, processing fees, that's for you to get your money. So that's your expense coming out of the trust account on fees you haven't earned because you've already taken out your fees. So that should come operating, it seems to me.
But there's nothing in the code that.
Doesn't matter.
I mean,
You got to think of it as, what you have to think of it as is what's the lawyers and what's the clients. They can't list every possible thing that is, so they're not going to list it in the rules. You just have to think to yourself, what is, the processing fee is paid by the lawyer for taking the credit card. They pay 2%. Well, I don't know what they pay because I don't take credit cards. I don't want to take credit cards because people later can dispute the fees, whatever. But some people take them. I get it. So that's what you're paying. The client's not paying the processing fee. So if that's you, then you're not taking that out of the trust account. That's a cost of doing business coming out of your operating account.
Margaret, are they charging the processing fee to the client?
Yes, so if they take the $5,000 retainer and Square charges them 3%, they're charging that 3% to the client.
So they're charging 5,000 plus
Into the
3?
trust.
But if you know that, can't you say like, the processing fee is going to be $200, so I'm only going to, even though the fee is $5,000, I'm going to charge you $48 because the processing fee, I don't know, you could do something like that probably, but you're charging, and then you're getting less, so you're paying that fee that way. I suppose you could do that. The key is the client getting screwed, I think, and I don't think they are by doing that. And are you putting anything that's yours that's not a fee into that trust account because you're not supposed to. You're not supposed to pay your office fees from a trust account. Trust account only has client money in it and money you've earned that you must immediately take out as soon as you earn it. Nothing else can go in the trust account.
So I take credit cards pretty extensively, and I do use LawPay. I've used other companies that will accommodate that, where they take it out of the general account. So it's not
LawPay.
Yeah, it's not the only one, but I do think LawPay is the best. And the problem with charging them ahead of time for the merchant fee, is that it differs continuously depending on the type of card they're using.
Oh,
You
yeah.
get
See,
little
that's a problem.
dings for their benefits they get for using their credit card, so that varies with each charge that you make. So you can't predict it.
And
Just
from a
3%.
marketing standpoint and a client standpoint, they feel it's being nickel and dimed. Up your fees to include your processing charges.
Yeah.
That's part of your
Yeah, that's what I tell lawyers. Like, I don't nickel and dime. Like, they're not going to get postage charges, copy charges, unless they want me to copy a baker's box and I have to go to Office Max or whatever. But I don't, I just have my fees enough to where it covers it. If I take the BART to go to a hearing at the bar court, I'm not going to charge them for the BART ticket. And I just do it that way. And clients like that because they don't get little bills after they've already paid me a big retainer for my costs.
So you keep using this term retainer, but I think it could mean different things. Like there's the true retainer, there's the retainer as an advance fee.
Retainer is
There's
often
the
mixed
average
up
fee.
with flat fees, advance fees, and all that. Yeah, there's different types of retainers. I'm talking about a flat fee because I've told you guys that that's what I do. There are true retainers that you could get if you're just so darn wonderful that people want to pay you to be available for them. And, so you're just wonderful. And people get it. Big time criminal defense attorneys, like in Florida and stuff, that represent El Chapo. They're going to die if they don't win the case. So I guess it's worth it to take, $500,000 to be available. But the key again is you can't bill against that $500,000. So it's El Chapo actually says jump, you got to jump. And then if you do 20 hours of work, you say thank you for the $500,000, El Chapo, and here's a bill for the 20 hours I did. And he has to pay it. That's a true retainer. Once you bill against that $500,000, you say, look, it's only 20 hours, El Chapo. I'll just bill against because you're afraid he's going to kill you. I'll go against the $500,000, please. I won't send you a bill for 20. Then you haven't earned the $500,000, and you got to refund him $480,000 because you haven't earned that retainer. So you don't want to ever bill against a true retainer. And we talk about them in 1.5 of the new rules of what a true retainer is. So there's true retainers, flat fees, advance fees. But the rules now, I will tell you, they're good. The 3 rules, these are the 3 rules. 1.5.1 and 1.15. Those are the fee rules. And they're very well written, and I'm not patting myself on the back here. I'm saying they're better than they were. They're clear on what you need to do and the definitions of the types of retainers. And we did that purposely so people could actually understand the rules.
All right, are there any final questions from anyone?
So I'm doing flat fee on estate planning and then on trust accounting and trust administration. So I'm trying to avoid the trust account. If I have it open and I'm not using it for a long period of time, is there any sort of check that I should be doing with the state bar?
What do you mean, a check?
Like there's zero balance for a long period of time, is there any sort of?
No. The state bar will ask you every year. Often they'll send something saying, you know, what, have you earned any money in the trust? Sometimes they do that. What's going on with the trust account? You just say, no clients, no money, thank you. And they disappear, you know. They're just there to try to see if there's anything, you know, for the client security trust fund or anything going on in that. But, you know, yeah, it can be nothing in it for a long time. And banks aren't allowed to charge fees against trust accounts. So it shouldn't be below zero because they charge you some kind of processing fee or something.
Any other questions?
How does the bank, you might ignorant, how does the bank make money if it can't charge fees against the trust account?
Because trust accounts are, you know, they're for settlement, so
Okay.
they get good money in there. They want trust accounts because so a lawyer could settle a $5 million case. They want that kind of dough going in their firm. So they're happy to have trust accounts for lawyers. Anyway, you can always email me or probably anyone on this panel later if you think of a question that you couldn't ask. And, you know, if you go online, you'll see our names and find us, and we're happy to respond to questions.
I like mentoring new attorneys, so if anyone wants advice, I'm happy to talk about anything to do with the practice of law.
She sounds like she'd be great too, because her eye is on the ball and the money. And a lot of attorneys, they're not. So that's good.
Another question?
I came a little late, so I'm not sure if you addressed this or not, but like the hybrid agreements where you get an upfront fee and then, let's say, you know, a percentage of like the settlement or a percentage of like a back-end agreement, you know, is that?
Reasonableness of the fee overarching. You can't get greedy with those. It's easy to get greedy with a hybrid flat fee and percentage of recovery. And that's where the problem comes in with those agreements. You have to be really careful about it not ending up being super high with no real contingency, because you're always going to make a ton of money and it screws the client. So you got to kind of be careful about the reasonableness of those fees in hybrids. I think that's where the problem comes in with them. And it's easy. The tenants, and I say that of myself, of any lawyer. It's easy to get greedy when someone's willing to pay a hybrid. You're like, oh, then I could get some at the back end and some, and I'm always okay and I don't have to worry. Well, that's when lawyers get in trouble. Because clients nowadays, let me tell you something. They used to not complain as much, but guess what? Now that complaint forms are online at the state bar, complaints have increased 180% or something, because they just go on and fill out one page and go, now I got that attorney in trouble. And it's like, it's great for me and my business, but it's not good for you.
All right, thank you for coming. Hopefully you'll be back next time. You did a great job.